Yo yo, what's good YouTube? It's your boy, Lawless, back with another one. So we're on C for spaces. That's consent. Um, so this, exception to the warrant requirement. It also is an exception to having probable cause since one is consenting. And the rationale basically is that the community has an interest in giving consent to like searches of evidence. Um, that way, the evidence can be collected and made sure like the community or that person is innocent and is like not wrongly convicted. Um, and then there's what two elements that go into this. So the consenting party has actual or apparent authority to consent, and the consent was freely and voluntarily given, and was not a product of like duress. So consent is just it's voluntary if the product of an essentially free and unconstrained choice by the maker. So your will must not be overborne. Um, yeah, basically how you describe it. That's when you're consenting. Um, if you're like, if you're, I don't know, seized for some reason, and it's like illegal, not a lawful arrest, or not a lawful Terry stop, um, any consent from that is tainted. So, I mean, that may fall into the exclusionary rule. Uh, yeah, fruits of the poisonous tree, whatnot. Uh, the government bears that, the burden to prove the those two elements, the one that it was actual or apparent authority, and that it was freely and voluntarily given. They just have to prove that to a preponderance of the evidence. It's not going to follow that whole beyond a reasonable doubt. Um, the consenting party is allowed to like limit the scope of their consent to like what is being searched. Um, and you can withdraw your consent at any time. Uh, but actual or apparent authority. So I guess we'll have to break that down. Um, so authority to consent can come from like an actual owner, um, roommates, like joint tenants, users are like a common authority over some kind of property premise, and others whom it's like reasonable, well, on the apparent side, others who are like reasonable to believe that they have the right to consent. So in apparent authority, like analysis is usually triggered um, only if like that person who consented didn't have actual authority. Then you're gonna like, oh, well, do we have apparent authority? Um, so from the case Chapman v. United States, um, regarding like a actual authority, uh, that the court held that the landlord did not retain the right to authorize a general search um, of the premise or the property. Um, so yeah, they threw out the police's search. Just that the landlord doesn't actually have actual ownership of that property. I mean, that's in a kind of a physical control element of it. Um, but yeah, so the tenant would need to be the one who gave who gives the consent. United States v. Matlock. This case, the Matlock was, I think there was like a warrant. They arrested him. They took him out of his house. Then they went back in to his house. They talked to, I believe it was his wife. And then she consented, because she's not a real one. She consented to a search, and yeah, it was perfectly fine for a cohabitant or joint occupant, joint tenant, to give the consent for a place to be searched, in the absence of the other cohabitant or co-occupant. But there is like a little caveat, like you can't just, your consent goes to areas that you can actually control. Like if you have separate bedrooms, you can't consent to having another person's bedroom searched. Actually, I think it's Georgia v. Randolph. Both tenants were, oh no, that's a different case. Both tenants were present. And as a general rule, the consent of one person who possesses the common authority over that premise is valid, as it's valid in the absence of their in the absence of that like non-consenting party, or whether cohabitant. But when they're both there, both people have to consent. If one does not consent, then you can't search. And then if one, there's an exception that if the both people don't consent, then you're going to have like an actual clear like hierarchy. So like a parent to a child, if your child doesn't consent but the parent consents, the parent is going to override the child's non-consent. Let's see, Stoner v. California, and that one was basically that the the night clerk consented for their hotel room to be searched, and the court just held that, the police officers could not reasonably believe that the clerk had authority to consent to such a search or of someone else's hotel room, or tenant's hotel guest hotel room. Illinois v. Rodriguez. The Supreme Court held there that the Supreme Court held that the police did not violate Fourth Amendment when they entered Rodriguez's apartment without a warrant. And then the court agreed that Fisher, he was like the joint tenant there, or co-occupant. He didn't have he wasn't even a tenant there. He didn't have actual authority to consent. But that was fine, because the court was like, well, even though factually he's not the actual owner, he can be an apparent owner, or have apparent authority to consent. And yeah, it was kind of based on the circumstances that were surrounding it, because it's more than just saying that, I live here. You're just gonna have to have some other indicators or indicia that shows it's reasonable to believe that you have authority to consent. Now, voluntariness. So, Schneckloth versus Bustamante. I get that part right. The court here, the court disagreed that the proof of knowledge of the right to refuse consent was a necessary prerequisite in demonstrating voluntary consent. So basically, even if you don't know that you can, even if you don't know that you can refuse consent, it's not a defense. It still can be, your consent can still be considered voluntary. Um, Bumper v. North Carolina. Uh, so here, law enforcement officer claimed authority to search this person's home, Bumper's home, under a search warrant. And since he announces in effect that when he makes that assertion, and in effect tells the occupant, like, you don't have a right to resist the search. So again, that will be, so like if you have that warrant and he actually did have the warrant, it doesn't matter if you had consent, you can't refuse because they have the warrant. So since the officer did that, he actually overborne Bumper's will. So it was coercive or in nature, just forcing him to consent when he has a warrant. And then last, Florida versus Hamino. Here, they thought, Hamino was transporting drugs. They asked Hamino if they can, like, search his vehicle. Hamino consents. So the when they were searching it, they ended up searching like a container, found some drugs, and Hamino's like, oh, we gotta tell my attorney I gotta get this excluded, but yeah, the court held basically that the standard for like measuring the scope of a suspect's consent is that like objective reasonableness, like where a party. So as I kind of said it earlier, but like if you don't put a limit on the scope of the consent, uh, then the scope of that consent will be guided by the officer's interest. So, or at least their interest at the outset of their stop or seizure. Yeah, that is consent. That was a lengthy one, I know. But thanks for sticking through with it. Sticking through with it with me. And till next time, peace.